Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court and CPS issues. I'm your host, Maryann Petri, and since 2016, Monica Shimonik has been coaching moms and dads as they navigate through the treacherous waters of the family law racket. Aside from workshops which help with specific problems, her 12-week signature course, The Best Interest of the Parent, uses a 4-quadrant model to create a robust healing and empowerment system so that you control the narrative in your life, not the state. Use coupon code SLAMTHEGAVEL to get 10% off the course, and this will be in the podcast notes. Now, I've got a great guest. His name is Mark T. Andrews. He is a father of 2 and part of the family court legal system. He is also a 13-year veteran licensed officer of the court known as a process server, working for hundreds of lawyers, 15 investigators, and 3 judges. Mark is also the man who submitted the Family Court Whistleblower Complaint to the Congress through Congressman Mark DeSaulnier and Khanna. They then submitted it to the Oversight and Reform Committee. This is now opening up talks regarding family court reform. There was also a federal civil rights case Mark filed, which is 17 CV 00252. Federal Judge William Orrick III, also the judge that handled the first Trump travel ban, well, he ruled on his case that judges have absolute immunity from suit, even though violating your constitutional protected civil rights. Mark's case spanned 18 years. He has been in front of 15 judges, 3 commissioners, 73 hearings, and hauled into court 11 times by warrant. He hasn't seen his kiddos for less than 1 month's worth of hours. And all this time, his ex-wife has never once been held accountable for not showing up with the kiddos. The kids haven't been allowed to come over for visits in the summer, nor has their father been allowed to take his son to a football game. He has had to visit in a 4-block radius in a town called Sonoma. No parent should have to go through this or be treated like this. Divorced since 2002, and has last seen his kids in the first week of January 2004 in his own home, and last seen them together was April of 2008. Mark last saw his son for 1 hour in a therapist's office, costing $125 per hour. Now, this judge violated civil rights in the family court proceedings. And I welcome you, Mark T. Andrews. How are you today?
Hello, Maryann. Thank you for having me on, and thank you for supporting getting my case out there into the media. I really appreciate this time on your podcast.
Oh, most definitely. We're here to learn from you, and we want to know, how did this parental alienation come about? I mean, with all of this that you had been divorced since 2002.
Parental alienation is it's a slow killer. It's like those who smoke almost. You know, you don't think nothing of the first cigarette. You don't think nothing of the first missed visit. Then you get 6 months down the line, you get a year down the line, and, you know, you're not seeing the kids, Then in my case, you know, I'm in year 19 of my case, and I can tell everybody with complete accuracy that if you add up all the visits, 1 hour here, I may have had 2 or 3 overnights real early on, but it didn't amount to 1 month's worth of hours in 18 years. And that's, I mean, I married her. I got to deal with what happens between us in the divorce. But the children's rights, their right to their father, their right to have time with their other side of their family, grandparents, their grandmother died 7 years ago, wasn't allowed to go to the funeral. Their grandfather's now 78, going on 79 years old. Can't see or talk to him. And they've just been completely pushed out of our lives. We've been technically, I think the hashtag now online is erased. Mm-hmm. I've been erased.
Oh, that is so wrong. It's so sad because, as you said, they missed out on their grandmother's funeral. They've missed out on a relationship with her when she was alive.
Yeah.
And it's just amazing that these people do this to these children.
And they think somehow they're protecting them. I mean, because I've owned in many times, you know, when I started my divorce, I was the party boy. You know, I used to rock bands and all that stuff. And I used to be very irresponsible. And it wasn't until 2 years into my case that I was working through and I got sobered up. Another 2 years beyond that, I became a court officer serving process, and I just improved my life. And I did that because I wanted my kids in my life.
Mhm.
And the way I was acting that caused my divorce was never going to facilitate a relationship. So I had to grow up and get it done, and I did. But the kids weren't allowed to see it.
And that's not right either. To watch you grow and come about, and then not being allowed to see your side of the family as well. They're missing out on aunts and uncles and grandparents that care about them. And
Cousins, all
seeing
that.
right, and seeing their father and father's advice on, topics and subjects that they should be aware of, that you would want to tell them about.
Yeah, and it's a travesty complete, and it happens to both sides in this big fight that we have. The family court corruption that we're dealing with, because I deal in fathers' rights. I'm a father. Of course, I'm going to deal in fathers' rights, but that doesn't mean I'm against mother's rights. I was very for mother having rights. I wanted 50-50 custody. I never saw it once in my case. We jumped through every hoop the court gave me. Drug testing for years, cleared and pulled off twice. Went through parenting courses. That 2-block square radius was a 2 years, I call it a 2-year sentence, because I had to travel an hour and a half to get there. You have a 4-block radius as a park. There's some monkey bars, there's some sand pits. There was actually this really neat duck sanctuary they had there. And my daughter, anybody else walked into their duck area, ducks all ran out. My daughter come out, "Father, meet Quacky." And she'd go back and bring out another one. "Pet this one, Dad." And it's like, how do you do this? I mean, these are at least some great memories I have from it. But yeah, for 2 years we were stuck. Every weekend we'd have to be in that park. It's like, are we going to eat at Mary's Pizza Shack today? That's the only restaurant,
Wow. Yeah,
And so,
that's it's so sad that you've got just a couple memories.
And I remember when I was seeing them at that time, like in the park, I'd reminisce on the things of them, being 6 and 8 years old, and they're like, "Dad, we're growing up," and we never got to have those memories as they got older. And like I said, the last time I saw them was February. Got me in the morning. First week of April, 2008. I went for a visit, and that was the last visit I saw them together. They were 11 and 13 years old. And then my visitation was taken away on a false allegation for 2 years. And when I proved that false allegation false in court, I had them pull out the paperwork, and I had the lady read it in court. And all of a sudden she stops. "I may have misspoke, Your Honor." "No, lady, you lied." And the judge stood and nailed her for it, because those kids lost 2 years, 2 whole years of visitation with their father. No Christmas, no birthday, no nothing. And then turn around and says, "Well, we're going to give you 1 hour with your son in a therapist's office," after 2 years of no visitation. That's insane. And that's where I went to appeal that decision. And that was how the video that everybody sees online with Kids Matter, with the evidence, where I asked the judge about, where's my hearing? They took away my business license, my driver's license, because I tried to appeal that decision because I wanted to see my kids more. And going into appeals court, you got to pay, your appeals fee. You got to pay a designation of record, and mine was $1,900.
Oh, I did not know that.
Yeah, to have my record printed up, they sent me a bill. They said it's $1,950, or we're going to default you. And they had taken away my business license in California, which what I used to do was I used to fix cars with dealer mechanics. And if you don't have a license and you go fix a car, something happens, you're liable. Plus, it's a $2,000 fine that the state gets, and then you'll have to refund the people all their money. So I couldn't work, and that was how I started pressing into the process serving business. I was just doing that on the side for extra money. And then it turned out to be more of a guerrilla warfare endeavor where I started getting around different lawyers, a lot of family lawyers, a lot of civil lawyers, some really high-end lawyers I've worked for. You learn the talk, you learn the walk. And this is where I've been helping people out. I can't tell you how many times people will call me and they're like, they're telling me, I've got orders and they just won't obey them. And you tell them, well, it's simple. Write a motion to compel them to obey it. Ask for a sanction with it if they don't obey it in so many days. And then if you attach the order so a judge doesn't have to do anything but sign it and ship it, you're likely to get your order.
Right. Yeah. Yeah, once you learn the lingo and the language that these attorneys, and it's like, why can't they just say things in just plain English?
It's like a foreign language. And what they really get mad at is like someone like me. I've been doing what I've been doing now 14 years, and I do it statewide. I specialize in the hard to serve and hard to find. And when I walk into court, I can speak the language. And I'm like, well, you're not an attorney. You're like a little upstart. You're like, no, I just happen to read the law and I know how to speak the language. I got the dictionary and figured out what you're talking about. I know what res judicata means. That means the end of a case. And you just got to learn those little things that they all take time, 4 years in law school to learn.
Yeah, and they don't like it when you know what you're talking about. I think that's when they start calling you crazy. I don't know if you were called crazy in court. They pulled the mental health card.
They know better than to call me crazy, because one thing, when I was sobering up in those years, I had a guy who he would turn around. We roomed together for about 6 months. He was a Vietnam vet, and he would make me walk around all day and talk in just this tone. No matter what I said, if he couldn't hear me, I had to walk in the other room so he could hear me. Never raise your tone, never show your emotion. And he drilled that into me. He goes, in that courtroom, you never show that emotion, because they want to work you up and they want to get things where they separate people, because that's how they make money.
Definitely. And facts don't have feelings. And people have to realize that when they write a motion and they're in there, it's all facts.
Yeah, you've got your issue, you've got your fact, you've got your law, and you've got your conclusion. It's as simple as that. So many people want to go into court and want to tell the judge every detail. You really don't need to do that. You need to find out, what is the issue. Okay, mom didn't show up for a court-ordered visit, or dad didn't show up for a court-ordered visit. Okay, then you would say that if you may try a letter. If you refuse to show up at another visit, I'm going to be forced to seek a contempt order. And contempt can give you up to 5 days in jail per count. I got one lady I help in Idaho. A guy missed 600 visits in the course of their custody matter. That's crazy. And why didn't the judge do something for that mother? Why didn't they turn around and, let that child see her mother? And those two, I got to know them personally, because I've served in her case for 9 years. And those two were, just a mother-daughter like you want to see. And nope, it was broken up. He was actually a rich guy, owned a couple of towing companies, and he knew some people. And at one point they took her daughter, and she hasn't seen her in like 6 years now.
That's sad. And so that relationship's destroyed now.
Yeah. Well, she was just talking to me recently, and she was like, she tried to talk to her daughter, and she's like, Mom, you don't know how it is here. I can't talk. I'm going to get in a lot of trouble. And she just hung up the phone. And she's afraid to talk to her mother, because she lives in a household that she will get recourse for trying to be with mom. Yeah, my kids went through the same thing. My kids are, mom's going to ask me all about this when I get home. So I would try to keep things very simple. And every once in a while, like there was one time where, okay, I brought water guns. Everybody's getting wet today. And they went home soaking wet. Mom wasn't happy, but we had a blast.
Well, you have to make happy memories. This is the part of childhood that they need. All these kids need happy memories growing up as kids. Because life is hard. When they grow up and hit 18, go to college and get a job, they're going to find that, life is full of hard knocks. And maybe they could look back on their childhood and say, oh, I remember this and that, when they're going through the rough times.
Right. And you also got to think about, what if that child finds out years down the line that, wow, I was lied to? You know, I mean, the revelation, if they've missed my kids, again, my daughter hasn't seen me since 2008. That's 13 years. And at a certain point, I mean, I'm going to try to go out to her home in Dover, Delaware to visit her and talk to her. And, you know, if she does finally talk to me, she's going to get, you know, the other side of the story, as they say on that radio show.
Right.
And I'm not even into attacking the mom anymore. You know, I'm not into fighting with her. I'm fighting with the officials that facilitated what she did. You know,
Right.
it doesn't pay to just keep, I fought mom to get visitation. They're of age now. My kids are 24 and 26 respectively. My daughter graduated Arizona State. Other than dealing with me, I would tell you my ex-wife was a great mom. I will never argue that fact. My daughter graduated at Arizona State. My son, I understood, went to Davis College here in California. I'm proud of that. Their mother got them into school, got them, you know, to educate themselves. They seem like well-adjusted, happy kids. They just, unfortunately, because of the alienation, don't want anything to do with me, and they don't understand why. All they know is they've been programmed for years in the household they're in that the other guy is the bad guy. Yeah, and that didn't happen to either parent, father or mother.
You were the target parent, and this is going to affect 6 generations of their lives. Dr. Mark Roseman had said that it would affect 6 generations down the pike.
I hope not, but if that's the case, it's going to be sad.
Right. A lot of parents are in this boat, and you know they don't know what to do. I mean, the kids age out. They have no contact with the kids anymore. And
I also recommend to parents, you know, especially ones who are I get people who talk to me for like an hour and a half while I'm on a drive, because I drive everywhere doing my job. And I tell them and say, hey, you know, if you're like a lady last night that I was speaking to from Southern California, her son was ADA autistic, and she kept turning around. This is another one where she's like, I got court orders for them to test him, and CPS won't test him. And I go, well, then write a motion to compel the court to make them obey the order and turn around and attach a sanction. Start at 1,000. The next one's 2,500. Then go to 5,000 and see how long they want to keep not obeying the order. You know? As a matter of fact, the rule for family law, they say the remedy for egregious conduct in the family law bench is to nip it in the bud with appropriate sanctions.
Right.
And that also comes from that Robert J. case.
And this is good to know. I'm writing it down. Parents need to know their rights, especially when they're dealing.
Start reading the laws. That's what I told that lady last night. I says, you're very passionate. I mean, she started to get to the point where she was repeating things. I says, you should start reading the Americans with Disabilities Act. Read about the laws. Read about the penalties. I said, you'd be amazed at how the federal government backs up. If a line on a sidewalk is off by an inch in a handicap spot, that's a $2,000 fine.
Huh. Well, there it is.
I mean, they get people go out there and measure these things. So in family law, start reading the family laws in your state. That's where I got in with the evidence that you saw in the video. Was I turned around and read the law, and the law said that I get a hearing in 30 days or I get my license back. Well, the judge in this case, who they basically, if the people read the transcript there, she says, until you're on board, until you start getting, you know, some payments in, I generally don't do anything to help anybody, which kind of is the definition of extortion.
Right.
You know? Doesn't matter if a hearing clears all this up, as long as you get paid, then you might want to fix it for me. And that was what I had the big problem with Louise Bales, Fight Master. And even my attorney that helped me at the time, he's like, everybody knows she's corrupt, but try and fight the judge. His goal was to keep me out of jail, because if I didn't give them some money, they were going to roll me up and stick me in jail. And that wasn't going to work. And this is where, when I read the law and I saw that it said 30 days, I went to the county and I did a Public Records Act, and I got copies of things in their file. I got a copy of the notices. I got a copy of the stamped receive response. And that's the key piece of evidence, because the date they say they received that request for a hearing from me, well, they've got 30 days to give me the hearing or give me my license back, or they're in violation of the law.
Mm-hmm.
You go a little further down in that very convoluted law. It's called Family Code 17520. The last bite at the apple they get is when you approach a judge, which that transcript was the hearing that I approached the judge. And I said, ma'am, where's my hearing? And she said, you're not entitled to a hearing under that area of family law. And that, in fact, is the first element of, as we were talking about, fraud upon the court, which is probably the most serious crime in a courtroom because it affects the mechanism of the court. You know, she made a false statement of material fact. The law said I get a hearing in 30 days. Why does that judge making $100-something thousand a year not read that law? Especially one who'd been in that courtroom for 9 years adjudicating child support. And also, I caught her at the end where I wanted to get it on the record. I figured I had to prove at some point that she knew the law. And I say at the end, ma'am, you're aware of the Southwick matter? And she goes, I'm painfully aware of that. And Mr. Southwick was another father like myself. Matter of fact, he's the one who introduced me to a lot of these laws and taught me how to research. And he turned around and had his license taken away for 14 months as a contractor. And he walked in and he's like, ma'am, I want my hearing. And she finally got so frustrated. She looked at Paul. She said, your driver's license is gone, hit her gavel on the bench and walked off. And his driver's license wasn't even before the court. He was just trying to get his contractor's license back. But what that means in my transcript when I asked her about it and she goes, I'm painfully aware of that. It was at that point that she admitted she knew the law because she had to have dealt with the law in that case. So one of the elements of fraud upon the court, the second element, the first one is a false statement of material fact. She said I wasn't entitled and I was. The second is, do they know better? You know, so I got in the transcript, I caught that little narrative where I asked her about a case that she would know that law. And she said, I'm painfully aware of it. Beautiful admission.
And it's catching them. Yeah.
Right. And then I added on top of it, I got to know her curriculum vitae, as they say. She became a lawyer in 1968 at Lincoln Law University. I believe that's in New Hampshire. She came out here to California in 1996. She became a family law specialist. She then became the family law facilitator for Sonoma County. In 2004, she was appointed to the bench as a commissioner. And at the time she heard my hearing, she was on the bench 9 years. And if you'll notice, this is how well I know my case after 19 years. I haven't picked up a single piece of paper, and I can dictate this out to you. Okay?
That's excellent.
The third element of fraud upon the court that we go into is, and this is the hardest one. Everybody thinks they can prove this, but this is where everybody's case will fall apart with fraud upon the court. You have to prove they intended to deceive the court. And that's where those two transcripts that Kids Matter was so nice enough to help me publish and get out there on the internet. The first transcript I got in 2014, right after, a little bit after the hearing, I noticed a narrative where the judge asks me, you know, if you wanted a hearing, you have to file papers with the court. And I say, I did. This is a very relevant point in there because at that point, the prosecutor for the county should have opened up his mouth and said, Your Honor, if it pleases the court, I'm in possession of a letter requesting that hearing. He said not a word. That's a Brady violation from a prosecutor. Okay? That should have been over right there, but it wasn't. And then in the transcript, she goes, well, you know, I'm not going to hear this today, but I'm going to take your oral motion for a hearing. Okay, so if you're taking my oral motion for a hearing, you can read the rest of the transcript. Where does the court clerk tell her the date and time of the hearing? She doesn't. Where does the attorney that's representing me in the criminal matter listed in the court's summary ever ask the judge, can I have the date and time of that hearing, Your Honor, so I can have my client there? She doesn't. I asked where my hearing was, and I don't ask where the date and time is. And the final piece of proof is that court summary. The court clerk never lists in the court summary that Mr. Andrews had asked for an administrative hearing and the judge is granting the oral motion. It's easily proven that that transcript was altered. But that Mr. Southwick, the gentleman I spoke of earlier, him and I get to talk, and he's like, if they mess with your transcript, tell them you lost it and order another one and see if they mess with it further. So I did. Turn around, it's only a 6-page deal. It's $22. I've paid the lady. I get another one come up. I open the envelope, and lo and behold, my lawyer's written out. I'm in pro per.
Oh.
They wrote out my lawyer, and the county's prosecutor is the one asking things on my behalf in the transcript.
Wow. Wow.
I mean, and so this is blatant intending to deceive, and there's only 2 people who could have altered that transcript, the judge or the transcriptionist. And I don't think a transcriptionist has intent to do all that because she's getting caught violating the Constitution. It's the judge who was violating the Constitution and trying to cover her tracks.
I agree. I agree.
I mean, anybody with common sense would look at that and go, no, it's got to be the judge, because this other lady wouldn't know anything of what this guy's talking about. She's just sitting there typing whatever he says, right?
Right.
Okay, so now you go to the 4th element of fraud upon the court, which is, did you have to rely on the words of the defendant? And again, where I said in the transcript, in the very beginning and toward the very end, she's like, remember, until you get on board, and usually that requires, some payment of money. I generally don't help people in these matters. Okay, what did I have to do 8.5 months later when she had no jurisdiction to do this? I had to give her $500 and plead to contempt to get my license back. So I did have to rely on her words. And then the last element is, were you damaged? Every day of erroneous deprivation after the law allowed that they didn't give those licenses back, I'm damaged. I clear all 5 elements clearly, convincingly, whatever you can call the highest standard of law. I've got evidence all the way across the board. And yet federal Judge William Orrick III, not once in 3 amended complaints did he ever even mention the transcripts, because he didn't want to get there, because that would prove something that they were doing wrong. His thing was to get me out of there because, as he said in his order, it's a well-established rule that judges can't be sued. And my case challenges that in this. I agree with qualified immunity that judges have. Judges should be able to get up there, make an adjudication within the confines of the law, and not have somebody suing them over it because they didn't like the outcome, though it be legal. But if, as in my case, a judge steps over that line from judicial act into criminal act, they thereby, like any other Tom, Dick, and Harry on the street that goes through the criminal court down the hall, she has committed a crime. It is a provable crime. And at that point, as was said in the 9th Circuit case, Hardwick versus County of Orange, it was Judge Stephen Trott, the 10th highest judge from the top at the time I researched it, on the 9th Circuit, Harvard man, knows his stuff. He looked at the lady and says, no official with an IQ greater than the room temperature of a room in Alaska should be on notice that if you violate clearly established laws, you have no immunity. And he actually cited a local case called San Francisco versus Sheehan in that decision. I mean, that's pretty clear to me. If you're an official and you're violating a clearly established law, like let's call it due process.
Yeah.
To be, not 1, but 2 amendments to the Constitution, and you're violating it, and then you're going to have a federal judge look me in the eye, and instead of defending a U.S. citizen and saying to the defense, you didn't give him his hearing. I have the summary right here. Okay? You violated his civil rights. No, Judge Orrick was more intent on covering the judge from getting sued, because they don't want pro per litigants coming in there. And, if I win this, they're going to get thousands of suits because of this. Now, granted, can't say how many of them will hold merit, but I've taken a lot of time to put my case together. As you said in the intro, I worked for 15 investigators. I've stepped outside my case and acted as my client. I'm going to put this together for Mark Andrews, and I started gathering the evidence. And before I walked into federal court, and believe me, I own this to this day, my knees were knocking under that table the first time I stood in a federal courtroom, because I was worried I was going to get my lunch handed to me. But I had to fight it because I'll use a poker reference. I had an ace high flush. I had everything in order. I've had numerous legal professionals that I work with. They all of them say, we can't represent you. Please don't ask us to crap in our own sandbox. I got to go to that courthouse. I got to go to that courtroom. And if I turn around and help you, I'm screwed. But they also looked at my paper for me out of respect for me, and the work I do for them. And not a single one of them said that it was invalid. Mm-hmm. They said it was going to be, an uphill fight, climb up a greased pole. But none of them said, don't do this. You're going to screw yourself up. Matter of fact, quite a few were like, pat me on the back, say, go for it. I hope you win. Mm-hmm. And then taking the courts after to the courts after Judge Orrick, I went through 3 amended complaints. I went to appeal his decision because his decision is easily appealed. Mm-hmm. He ruled on 2 platforms. He said that the Rooker-Feldman doctrine applied, and that the judge had absolute immunity. And we've already covered the second one, which, explain how the Ninth Circuit opinion says no official. But the other one, Ninth Circuit, I'm sorry.
That's okay.
I'm sorry, I lost it there.
Don't you hate that? I know.
I do.
I've done that. So you appealed?
Okay, so that's right. We're going to the appeal. The Rooker-Feldman doctrine, and this is something that all litigants should understand trying to get into federal court. Thank you for bringing it back around. The Rooker-Feldman doctrine here in California, it states that if you've lost in the state court and you try to go to federal court, they're not a de facto appeal court. They'll shoot it down every time, and it will toss you out of court, and you will just waste your money. What I did, and what made my case the way I could go to federal court, I said I didn't get my hearing, and I filed under Title 42, 1983, a violation of civil rights. The defense, knowing that I didn't get my hearing, still stated that I got that contempt hearing where I had to plead guilty and give them money. I said, well, that was your hearing. Well, no, that's not my hearing. I challenged the state statute's constitutionality. That would require we go to the administrative court in California, and it would also require that a state attorney general step in for the state of California, because I said the law is unconstitutional. Mm-hmm. Now, having dealt with court matters like you do, Maryann, can a state come in and take your property and then not give you a hearing?
They can do whatever they want.
Well, no, that's the theoretical thing that they play with. But legally, state can't just come and take your property. That's why the law is written like it was. It says the state comes in and gives me a notice, took my driver's license. The state was then required to give me a hearing in 30 days. In my case, they didn't. That's a violation of due process. Very clear. Judge Orrick took the defense saying that I got this contempt matter and said, you got your hearing. You're trying to, use this as a de facto appeal. And he wouldn't allow me to speak long enough to argue the fact and say, hey, wait a minute. You're saying I lost my argument. Show me where 17-520 was ruled constitutional in the administrative court. Because the hearing never happened. You can't show me a findings in order, then I have every right to be here because my rights were violated. And that's what he didn't want to hear. And when I tried to bring that to the Ninth Circuit Court of Appeals, I was ruled frivolous, sent out the door, and they added a note in my file that no further documents will be filed in this matter. Closed.
Huh.
Now, how do you close something when I'm going back to the district court, the lower court with Judge Orrick. I'm going back on a Rule 60 motion because the lawyer for the county, in fact, knew that I never got the hearing from the Public Records Act request. I have letters signed by him, and that he turned around and gave us the notice. He gave us the response, and where was the findings in order, sir? His response, I gave you everything in the file. That means he knows there's no findings in order in the file. Mm-hmm. And when he told that federal judge that I got a hearing, he was lying. and that is fraud upon a court officer. So that's what we're opening it back up, and we're just going to keep pressing it. You know, I refuse to let them get away with taking my kids, taking my money, taking my life, and then going, oh, well, sorry, we know you got screwed, but have a good day. I am way too much of a fighter for that. And God has blessed me with some really great support people. If I could do a shout out to a few people, Patrick Howley from the National File did the article on the submission to the Congress. I've had Mark Fiedelman with Kids Matter has put the video out recently. Alex Baker from Postmodern Justice Media Project has helped me out quite a bit. Andrea Wood was helping me get my stuff out there. She dealt with the Parents Coalition here in California. So I've been really blessed with some people who've seen what I've gone through, felt for me, and are helping me get this out there. And we want to take this as a national thing. I want this to be as big as George Floyd, because maybe my kid isn't murdered, or maybe I wasn't murdered, but I'll tell you what, if you've been a parent who's gone through parental alienation and you haven't seen your kid like I have in 13 years, can you imagine you saw your daughter at 13 and now she's 26 and you've missed everything in between? You mourn like a death. I've had 3 heart procedures in my case, one every 6 years. I've got 3 stents in me, and I just had open heart surgery last June. I mean, this takes a toll on you. And I got to keep working, and I got to keep reading up and learning new laws. Now I'm in federal court, so now I got to make sure I know federal rules, and I apply federal cases to it, and it's just never ending. And the problem is if the Judge William Orrick III would just look at this and go, the evidence is here. You didn't give him a hearing. You're wrong. If I were you, I'd go out and settle in the hallway before I make my decision. That's what should rightfully happen. But they're not going to do it because they're not going to allow me to win. And the only way that I will prevail in this case is if we make it a national issue. Because if they could take the rights away from me, one citizen, who's next? Is it Maryann Petri that walks into court tomorrow and a federal judge takes away your right? Is it Mark Fiedelman from Kids Matter who walks into a courtroom and a judge takes away his right? It's one citizen at a time. Is it a guaranteed right or is it not? Period. If I'm guaranteed due process, most people don't look at it, and it's a very simple thing. People go, well, there's all this thing about due process. Due process is as simple as this. It is the process that is due you by law. So you got to look at the law, and in my case, it said he gets a hearing in 30 days or he gets his license back. Did the state and county obey that? No, they did not. And they submitted records to the court proving it. And still a federal judge denied holding up my civil rights. And that is a sad travesty. We all need to fight that, because one right at a time, and they'll keep stripping them away.
And it seems like every federal judge is doing this, as we've talked earlier.
I can only speak to my experience with Judge Orrick, who I literally went face-to-face and argued with. Because in the first argument where he turned around and said the absolute immunity, I did the Robert J. thing. I did the Hardwick thing about no official with an IQ greater. The second time he tried it, I like asking judges pointed questions. So he says, you're not going to get around the absolute immunity, Mr. Andrews. And I said, well, Your Honor, I got a question. I read the Constitution and all the amendments thereafter. Can you please tell me where in these legal documents, because you're a legal scholar, you got the robe on, you've gone to school. I'm just a truck driver here in court. Can you tell me where in these documents it gives anyone immunity to violate the very rights that are protected and guaranteed under the Constitution? Please tell me who's above the law. And he goes, well, no one's above the law except the judge you're ruling that has absolute immunity. And they don't look at it that way. They're just protecting their own, and that's wrong. They should be able to police their, if a few of these judges got nailed for the egregious and perverse ways they've perverted the law, you'd have a lot less of it if a few of them were made accountable.
Right. Right.
But they make $180,000 a year, and we make like 30 to 50, and we gotta, hustle and working to catch up to what they know how to do.
Mm-hmm. Now, do you suggest that people report these judges to the boards? I don't know.
Well, you got to understand, it's a double-edged sword. I agree. You report things, report them to the bar, the state bar. If it's a bar violation, you report them to the judicial council. But once you do that, if you think you were marked before it, there's a big red X neon sign on you after that.
Mm-hmm. Mm-hmm.
That lady I work with out in Idaho, I think she's gotten one ruling her way, and that was for an extension. But other than that, she gets nothing. And she testified at the Elkins hearings here in California, which was supposed to help fix this problem in the judiciary and family law. All it ended up doing was getting Sacramento and Marin County raided by the state, so they would, try to correct things. And it's Sacramento B found Marin County was shredding documents the night before the audit. That's how worried they were. Right? And every parent who testified on that Elkins hearing, from what I've been told, has suffered in the court system. Not a single one of them have prevailed beyond that. So, again, a double-edged sword. But if enough of us come together,
mm-hmm.
It's got to start making a difference.
Right.
Remember that old Doors song? He says, "They got the guns, but we got the numbers.
Mm-hmm.
We're going to win." And that's what we got to start doing. I'm trying to, band people together with all these different groups. Let's not fight amongst the groups. If anything, together we are stronger. If we can take this to the legislators from border to border and from coast to coast, and this is a voter rights issue. If you're not going to help fix family courts and these federal judges who won't uphold the law, then you need to be voted out and put somebody in there who's going to help us.
Mm-hmm.
And that is one clear message I'm trying to group, the different groups that I talk to. I'm trying to get us all under one umbrella. And I've been working on that with my I Am the Storm podcast and project.
Okay. Now, do you think family court should just be abolished?
No. But if you actually look at it, right, and I've said this many times, if the laws of the state of California's family court system were obeyed in my case, there wouldn't be a problem right now. I think it was recently in the news, they said that Judge Judy,
mm-hmm.
Judy Chinlin or whatever, she's the one who came out, she said, failed politicians and any idiot with a bar license are the ones they put in family court because nobody wants to deal with it. Mm-hmm. It's so emotionally charged. Everybody's lying. That's the other thing they need. That's something they need to do in family court. You want to reform? If you're caught lying in family court, you lose 100%.
Mm-hmm. Mm-hmm.
That should be a law.
I think people crying crocodile tears on the witness stand, I think that also should be taken into account with what you just said.
Yeah, I mean, if they're lying about it, if it can be proven that
mm-hmm.
they're lying. See, because that was how I caught my ex-wife. Her lawyer was saying, Your Honor, this wasn't my client. This wasn't her daughter. This was an anonymous third party that saw this man in a park, and he was touching the child, and there's a police report. Funny part was the judge had the police report all the time, and the police report cleared me, mm-hmm. right? But after she says this, she did this in 2012. They asked me, so do you have any questions for the attorney? Hey, yeah, I do. I said, do you have your complete file? She goes, yes, I do. And there was a specific document in 2007, and please pull this out, and please go to this page. It's about the third paragraph down. Will you please start reading? And she starts reading the declaration of her client, turning it into CPS and the sheriff's department. You just told them that it wasn't your client, and yet your client submitted documentation saying it was her. What's the truth, lady? Mm-hmm. That's when she said, I may have misspoke. That lawyer should have been disbarred. My daughter was put through a sexual impropriety investigation because somebody lied and wanted to get an advantage in family court rather than let me, a father, have some rights.
Mm-hmm. Mm-hmm.
Oh. Hold on.
Okay.
I'm going to lose you. I'll be right back.
Okay. I'll wait. Hey, hey, you're back.
There we go. Sorry about that. My phone overheated.
I can hear you.
Okay, so where do you want to go next?
We were going to also talk about, the parental alienation, the fraud on the court, and I know there was another topic.
Those two covered.
Pardon?
The video, we're promoting the video. Kids Matter's been nice enough to step up and take the time to. Went down to Carlsbad, got the thing filmed, and they took all the documents and they wanted to put them on the screen so everybody could see that this is not just some whiny person. This is actually corruption that's been documented. And all the views we can get, we really appreciate anybody comes on, leave comments. I try to get back to everyone that gets there. Again, I want to thank Mark Fieldman, who runs Kids Matter, a great guy. I really appreciate his support in all of this. And if anybody wants to, know how to put things together like that, we'll, I guess on your website, we'll put up my email address, which is not to be taken away at live.com. My phone number is 707-280-7425. And, I've talked to people and help out where I can. I can't give anybody law. It's one of the ethical duties of a process server. Otherwise, I'd be practicing law without a license. But as a good friend of mine pointed out, there's nothing wrong with two friends sitting down over a NOLO book and talking legal theories.
Right.
That's completely legal.
Definitely. Now,
so we try to help. Try to help where I can.
That's right.
Go ahead.
You were kind of breaking up when you were talking about the video that was being filmed. Can you please go over that?
Yeah. Went down to Carlsbad with Mark Fielman and Kids Matter. They did the interview with me. We gave them the video footage, and then they wanted all the documentation. They wanted to highlight and put it right up on the screen so people could read right from the legal documents that this is not just, we're kind of thinking maybe we need somebody to test. No, this is hard documented evidence that corruption has occurred in a family court, without a doubt.
Definitely. Is there anything else you'd like to add?
Keep fighting for your kids. I know it's hard. I've suffered, through my heart attacks and whatnot, but they're worth it. I love my children. I miss them every single day. If they're out there, Ben, Kaylee, or I say Alexis now, both my kids, we call them by their middle names. My son is George Benjamin, and my daughter's Alexis Kaylee Ann. But I miss you both. I love you dearly. I long to hear that one word on the phone. Love you.
Definitely. And I'll probably have you back on as a return guest if that's okay.
I would be glad to come back for you, Maryann, most definitely.
Oh, awesome.
And if you want me, we can focus on certain topics, being, I have a wealth of knowledge of the court system. I have a wealth of knowledge of how to get people served if you're having trouble. And I'm also good at locating people. Often people ask me what I do. I say, I hunt people for a living.
Right. Excellent. Okay. Well, hey, don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms that in turn perpetuate parental alienation. I'm your host, Maryann Petri, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. Please join us again in the future with Mark and other guests. Thank you.